morning. You may be seated. So we are here on our case number 1CACV170697, Michael THIEME et al. Versus Mr. SZEWCZYK et al. And I apologize to both sides for mangling the names. So counsel, as you know, each side's allowed 20 minutes for your argument. Each of you may reserve time, if you choose, on your respective appeal or cross-appeal to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself. The clock on the podium will reflect the total amount of time you have remaining, including what you might have decided to reserve. We record the proceedings, so we'd be grateful to you if when you approach the podium, every time you approach the podium, if you'd give us your name and the name of your client for the recording. We've studied your briefs, and we've reviewed the record, the voluminous record in the case. We've also discussed the case in our conference among us. So with that, you may proceed.
Thank you, Your Honor. Judges, my name is Jeff Coughlin. I represent the SZEWCZYKs in this case, and they are the appellants. They've authorized me to file this appeal for three essential reasons that I will focus on. One is the jury instruction that was given to the jury. There was a 6-day jury trial in June of 2016. And at the end of that trial, the judge gave a jury instruction on breach of contract. That you can find in my opening brief, the appellant's opening brief on page 15, argument B. The second issue is the issue of attorney's fees under 12-341.01. That argument you can find on page 39 of the responsive brief to the cross appeal. And that is the second issue. Third issue is the issue of attorney's fees that were awarded under section 12-1103B by the trial court. That argument appears on page 41 of the cross appellee's responsive brief. There is a factual history that I'm sure you've gone through in this case. I don't know how many people are familiar with the physical dynamics of a shared well, or what goes into it and what comes out of it and what powers it, but it's crucial in this case because there were three properties. The well was on the Weber property. The pump that pumps the water out of the well to the three properties is on the Weber property, but the electricity that powers the pump is on my client's property, the SZEWCZYKs.
If the court had agreed with your client that the jury's finding of breach was effectively a finding of a material breach, what would have been the consequences for that, for the shared well agreement?
Well, according to the instruction, it excuses performance of the SZEWCZYKs under that shared well agreement. So what does that mean?
This is a matter of law. Yeah, what would that mean?
That, in my opinion, that means that the obligations that the SZEWCZYKs had under the shared well agreement would have been excused.
So they would no longer have to, they could unplug the well.
They could disconnect the power that goes to the pump, yes. Not that they would without giving anybody the opportunity to make arrangements, but that performance, according to this jury instruction, which was given by the judge after negotiation with counsel, excuses performance.
But what about the implied easement? Would it have any effect whatsoever on the implied easement?
Well, the implied easement is tied to the quiet title action, I believe, and since the quiet title action should not have been ruled in favor of the plaintiffs in this case, because the defendant's performance was excused, it becomes moot. So the implied easement, which is an easement for the placement of the pipes and use of the pipes that go across my client's property. I think you must understand the dynamics, because that's the issue of where the water goes from the well to the THIEME's property. It goes from the well that's on the Webbers across the SZEWCZYKs to the THIEME's. So yes, there are pipes. What happens to the implied easement is that it's moot. It has to be reformed under the shared well agreement, because the contract has to be reformed. It all goes back to the jury instruction, because if the SZEWCZYK's performance is excused, then the contract, the shared well agreement, has to be reformed. And it's not a difficult procedure to do that. It has to do with the remaining two parties to the shared well agreement, the Webbers and the THIEME's.
How would you reform it if you didn't continue to recognize the legal right to have the well on somebody else's property?
Well, the shared well agreement does state that those who are serviced by the well, that's one of the items in the agreement itself. The SZEWCZYKs are not serviced by the well at all. The Webbers are no longer serviced by the well. But I did offer an explanation and suggestion to the trial court about what you could do if you reformed the shared well agreement. The pipes could be relocated on the Webbers' property. They're a plaintiff in the case, and out to the right-of-way and to the THIEME's property. It doesn't have to cross the SZEWCZYKs, but they breached the contract. They were excused. The SZEWCZYKs were excused. So if you do any other questions about the implied easement, or shall I proceed?
Going back to the jury instructions?
Yes.
What's the significance of the earlier instruction that the court gave the jury, the one a page or so before the one that you quoted, just a general breach contract instruction? Doesn't that also bear on our understanding about what the jury found?
Well, I think the specific instruction controls, and this actually had to do with the breach. The judge, I think, misinterpreted what the language of this instruction was when he made his ruling. And I mean, the instruction itself doesn't say what the judge says it said. It is very clear that a breach of contract occurs when there is a failure of consideration or a material breach that occurs when something is so important to the contract that failure to have it defeats the very purpose of the contract. Every contract, if it's for money, money is a payment, is an essential ingredient of a contract, and it is so important in this case. It's actually what started this whole process, because my clients were not being paid by the THIEME's. So they said, we've had enough, you haven't paid us, you haven't contributed to what it costs to produce this electricity, we're going to shut off the power unless you do something about it. And they didn't. And they didn't pay either. So, and by the way, the power was never shut off to the shared well, and still hasn't been shut off. So that's not an issue. But the instruction itself says, for either reason, failure of consideration or material breach, if you find that there has been a breach, and the jury did, then the SZEWCZYKs are excused from performing.
Was the jury instructed about what those terms meant? Failure of consideration or material breach?
Yes.
Where was the jury
I don't know
instructed?
where that is in the instructions. I can't tell you that.
But you're sure that the jury, that among the instructions was one telling the jury how to measure such a breach?
I'm not positive. I can't imagine that there wouldn't be a definition of breach, material breach, or failure of consideration. The fact is, though, that the jury found that there was a breach of contract, and by looking at this instruction, that means that for whatever reason, whether it was a material breach or a failure of consideration, for whatever reason, the THIEME's breached the contract.
But that could have been under the instruction that just said there was a breach. A party breached a written term of the contract.
Well,
Why are we to assume that they found, necessarily found a material breach or lack of consideration when they could have just said, there's a breach under the general breach of contract instruction that the court gave?
Well, the court gave the Raja I-9 in breach of contract instruction, and that is a portion of that is what I just read to you. But the court went on to say that the jury was given the option of determining whether there was a breach, a failure of consideration, or a material breach. They were not given that option. They were told that a material breach occurs when you have either a failure of consideration or a material breach. And then the judge went on to say, I decline to interpret the jury verdict as a binding determination that a material breach excuses the defendants from performing under the shared well agreement. Well, that just ignores what the instruction says. The judge is saying, contrary to what that instruction says, I don't think that the jury made such a determination. Well, they did. They found that there was a breach of the contract. They didn't say, and they don't have to say, whether it was consideration or material. They found it. Either one excuses the SZEWCZYKs from performing. And that's the crux of this appeal, because if that is error, and that's an error, I believe, of law, because it's similar to an evidentiary rule or statute, it's a de novo exercise by this court. If that occurs, then the award of fees was incorrect, the determination of prevailing party was incorrect, the award of fees under 1103B was incorrect, and the SZEWCZYKs, who are the only ones that paid any attorney's fees in this case, should be awarded their fees. So with that, the second issue, which I've indicated appears on page 39 of the responsive brief to the cross appeal, has to do with the 12341.01 fees. Now, there is a history of the case where the judge had previously ruled that on a motion to compel something and awarded fees. When the fee application was submitted, I challenged that, stating that this is an attorney litigant and has not, under the Lisa case, cannot be compensated for incurring attorney's fees when he's representing himself.
But he can if he's representing others as well.
That's
what
correct.
That case holds.
That's correct, provided there is a bona fide obligation to pay the attorney's fees. That was an issue in the case.
Didn't Mr. O'Leary say that in his affidavits?
That
The clients have agreed to pay these fees or have already paid them when billed.
the judge did not believe that that was bona fide.
Well,
Why? Because they never paid
The judge
them.
believed it as to O'Leary's fees. I mean, by your account, he must have believed it as to O'Leary, but not as to THIEME, which doesn't make sense.
No, it doesn't make sense. It doesn't make sense at all, because
I mean, in any other case, wouldn't we take as a given and a verify by a lawyer for a client that the attached fees, the clients have agreed to pay these fees or have paid them? Wouldn't we take that as a given?
I think the key to your question is what you started with in any other case. This case is different because we have an attorney litigant that represented his 2 children and his wife and 2 other neighbors. And according to the judge, a phenomenal percentage of the work that he did was unreasonable. And so under the Lisa warning, the Lisa case warning, when you have attorney litigants, it's a completely unfair playing field because the attorney litigant can use his attorney knowledge and skills as a weapon. And that's what happened in this case. No fees were paid by his clients or by him. He didn't pay the O'Leary firm at all.
What in the record tells us that?
That he didn't pay the fees?
You just now said no fees were paid by him or his family.
Yeah, I think it's undisputed.
How do we know that?
It's undisputed. It was argued to the court. The court agreed. The court stated, I don't have the ruling in front of me, but the fees were not paid by the children, the wife, Mr. THIEME, or the Weber defendant, our plaintiffs.
I think what the court said is there's no evidence that the clients had paid. I don't think the issue was litigated, was it? Show me a check.
Okay.
No, I don't have a check.
Well, it was challenged, And it was submitted to the court that no attorneys' fees had been paid, that there was not any obligation to pay, other than a letter that was sent to the Webbers. I don't know, I can't recall whether or not the letter was sent to Mr. Thieme's family. That
I saw two of them.
okay, that this was the obligation. It was not signed by the plaintiffs at all in accepting the obligation and proceeding, but there was a letter, as opposed to the SZEWCZYKs who we submitted evidence of payment and an agreement, and what the terms of that agreement were. So I understand your point that there is no, what was the issue of, were no attorney's fees paid, litigated, as opposed to there's no evidence of having been paid. I don't know that there's a distinction to that in terms of the end result. So,
Well, just to clarify, there was no evidentiary hearing on the issue of attorney's fees, specifically. I mean, you didn't put
Yes.
Mr. O'Leary on the stand?
No.
I mean, to cross-examine him?
No, there was no evidentiary hearing. There was a ruling, and then there was a ruling on the equitable issues in the case, and then there was an argument set for attorney's fees. So,
Just
there,
to
but
clear-
there was no evidence. You're right. There was no one was put on the stand to determine who was paid what. But I think the record is clear that whether it be that there was insufficient evidence that any fees had been paid, the court found that there was not a bona fide obligation to pay the O'Leary Eaton firm by the THIEME plaintiffs or the Weber plaintiffs. And that no pay. I think the judge did say that no payments. There was no evidence that payments had been made.
So how does that finding, how is that consistent with the court's award of fees incurred by Mr. O'Leary?
In the 1103B fees, those fees for quiet title,
I'm not sure it
I
matters.
think
for
that's
this
the only
purpose.
fees that were awarded.
For clarification, I thought the court did not award any fees for under quiet title, only under the shared will agreement. The court awarded over $5,000 and change. I mean, I'm looking at page 6 of the court's order. The court awards fees under the terms of the shared will agreement. The court did not award fees under the quiet title statute or 1234101A. The court couldn't have done it under 01A because it's controlled by the terms of the contract.
Correct.
Okay.
That's correct.
Okay, just for clarification.
Let's see.
I see your time's running.
Yes, I know. Well, I would like to reserve the remainder of my time for my rebuttal. I have 3:22 left, or until he gets up here. Is that what it is?
I think it's until you stop. There you go.
Stop.
Good morning, judges. Michael Thieme from O'Leary Eaton on behalf of the plaintiffs, appellees, and the cross appellants, who are myself, my wife, Catherine Weber, and the estate of Michael Stavola. I wanted to just address a couple of things before I start into my remarks about what Mr. Coughlin said, and I think Judge Brown picked up on some of it. The fees were awarded pursuant to the shared well agreement only. There was no fee award made under 12-34101 because that statute is not applicable when the contract is in place. And there was also no award under 12-1103B because the judge concluded that since we had several legal theories, he was just going to award fees under one and not both. So that's as far as the attorney's fees. Now, what we're alleging on that issue is that because the judge only awarded a very small amount of fees, additional fees should have been awarded under the quiet title statute as well. Because, and I think we cited a recent case that was handed down by this court, the Cook v. Grebe case, that talks about attorney's fees under 121103B. The judge did find that we complied with that statute. As you may have noticed from reading our briefs, the point that we've tried to make is that this wasn't just a dispute about $480. This was a dispute about the continued existence of the shared well agreement, which the SZEWCZYKs wanted to get rid of. The SZEWCZYKs made it very clear that they were not going to allow the shared well agreement to stand. They wanted to disconnect. They indicated they were going to disconnect. When they were presented with a quitclaim deed for easement to acknowledge the existence of the easement, they didn't sign it. And that attitude of theirs continued throughout this litigation until the very end, even after the judge found that there was an implied easement, made his equitable rulings. We filed a motion seeking clarification of that. The response that we got from Mr. Coughlin and the SZEWCZYKs was, there's never going to be any need for Mike THIEME to go on my property. That was their response to after the judge found that we had an easement. So really that was the heart, the gravamen of this dispute. And we believe clearly that the plaintiffs were the prevailing parties on under the totality of the circumstances, totality of the litigation test. The argument that the SZEWCZYKs make about the not being serviced by the shared well, the judge explicitly found, I think in his judgment, that that is not an excuse for getting rid of their obligations under the shared well agreement. I think that phrase, serviced by the well, is kind of used as a descriptive phrase in the shared well agreement, which the judge himself found was pretty poorly written. But really it doesn't, it's not an excuse for someone to say, well, I'm no longer serviced by the well, so, you know, we're going to just let go the whole easement, everything is done, and we're just going to disconnect whenever we will. Clearly the agreement says it can only be changed by consent of all parties, and there was never any consent to change the agreement.
Also, talk about that material breach issue for a minute. If it wasn't a material breach, what was it? How can you have it? How can you get any damages for an immaterial breach under Arizona law? I mean, you can't, right? An immaterial breach is
well,
not,
I think the
is not a
judge's
breach.
comparison was very apt. I think the judge compared it to a situation where you have an HOA and CC&Rs, as we happen to have in our neighborhood, and that was another claim we had there. But you have a someone who doesn't pay for their monthly or annual assessment, say $100, they don't pay. Does that mean the HOA can now stop, can call the whole CC&R is done?
No, not usually, because it's usually laid out in a lot of detail of, you know, notice and opportunity to cure, and then
I think a failure of material breach would have been, say, the water ran out or something like that in the shared well. At that point, you would have had a material failure that would have excused performance because it was just no longer feasible. But someone's non-payment of 1 year of a or late payment, I guess, or
Well, it was unpaid throughout the litigation.
well, the $480 were deemed by the judge to be unpaid.
What, and that was your client's only obligation, your client's only duty under the agreement was to pay, and your clients didn't pay.
Yes, well, there was maintenance obligations as well, but for we didn't pay for those 2 years. That was what the judge
You weren't
found.
required to perform maintenance. You were required to pay for maintenance when it was performed.
Well, we did perform maintenance, actually, and I think that was...
Okay, but the point is, your duties under the agreement were to pay, and you didn't pay. So what other? Yeah, I can see the point. You had one thing to do, and your clients didn't do it.
Well, the other party did it. That's for one thing. And it was kind of an...
You mean the neighbors did it?
Right.
Weber's did it?
Correct. So I think it's sort of an unusual situation in the sense that it's not a two-party agreement. It's an agreement involving multiple parties. So I think to say that just because one party didn't pay 1 year, that causes a breach or excuses performance of the entire agreement for everybody, or I guess as they're claiming for us, I just don't see how that's practicable.
But help us understand, why was the court even, why was the jury even instructed on lack of consideration and materiality then, if it was just a simple?
Because
contract
that's what they were
matters?
claiming.
Okay, so there must have been evidence to justify that
Well,
instruction, or you
I-
dispute that?
we dispute that there was any evidence.
Well, okay,
I mean, the instructions I have in front of me, they begin by saying, you must take account of all my instructions on the law. You may not pick out one instruction or part of one and disregard the others. However, after you have determined the facts, you may find that some instructions do not apply. You must then consider the instructions that do apply together with the facts as you have determined them. So the jury clearly, I mean, Mr. Coughlin is focusing on that one instruction, but we have no proof that that's the instruction the jury decided was applicable, and that's why they, well, again, the jury award was set aside, or was
but
reduced.
following up on Judge Johnson's earlier questions, was the jury instructed on what consideration means or what materiality is? mean,
I would have to look through the instructions.
That's fine, we can look, but I just wonder whether that was pressed hard in closing arguments, or?
Yes, there is on page 2. It says consideration is a benefit received or something given up or exchanged as agreed upon between the parties. A promise or agreement to perform an act is adequate legal consideration. And to answer your question, our position at trial was that we had an agreement with them that we were going to do work in exchange for them waiving the payment, and that's not, I guess, the evidence presented on that isn't all in the record because the transcripts aren't before this court, but that was, I think that was where that instruction came from, so. Can I answer any more questions on these issues, or should I proceed with my?
Go ahead.
Okay. So again, just going back to real quickly to the jury verdicts, they're trying to argue certain inferences that they want this court to make based on a $20,000 jury verdict that they had originally received. That jury verdict is no longer at play, and any inferences that you could make from that are no longer at play because it's gone. It's been reduced. And I guess you can argue whether who really won on that claim when you take a $20,000 verdict and reduce it to $480. So, in terms of some of the other arguments that the defendants raise, clearly I think the judge was correct in determining the prevailing party. This was a dispute about the very existence of the shared well agreement and the easement. On which the plaintiffs prevailed. As for some of the arguments about attorney's fees and the application for attorney's fees, I'm not aware of any case that requires billing statements to be submitted with a fee application or prove that the fees have already been paid, or submit what I guess the judge referred to as proof of actual payment, whatever that would be.
Let's start, maybe we could help us with, on page 5 of Judge Mackey's minute entry, the July 13th, 2017 under advisement ruling. Towards the top, first he quotes from the January 2016 minute entry, and then I'm looking at the first full paragraph. Said the court finds that nothing has changed regarding the work performed by Mr. THIEME. The proof is inadequate that any of the plaintiffs have an obligation. The court didn't say genuine or not, but just I'm reading that as have an obligation to pay the law firm of O'Leary Eaton for the $86,000 billed by Mr. THIEME. So help me understand, why is that sort of factual finding right there legally incorrect, abuse of discretion? Explain to me what the court did wrong.
I could try to explain, I think, where that whole language came from. We had initially, back in 2015, moved to compel the defendants. We prevailed on the motion to compel. The judge said we should file a fee application or an affidavit of attorney's fees. The affidavit was filed. at that time, Rule 54 didn't...
Affidavit filed by who? Mr. O'Leary?
Correct. Who's the supervising attorney in this case. The affidavit was filed. There was no fee agreements attached to that affidavit. Back at that time, as far as I know, there was no requirement that you attach a fee agreement to a affidavit of attorney's fees. Right? Today, Rule 54, G4, I believe it is, says that you have to disclose the terms of the representation in any application for attorney's fees. That was not the rule back then. We did not include a fee, a letter of representation along with the application because we hadn't been doing that back then and we didn't see it as necessary. The judge, based on that, I think concluded that there's no fee agreement. So when we filed our fee application, the amended fee application, after we had gotten the judgment, we did include fee letters with the amended fee application. That amended fee application is Index of Record Item 258, and that did contain the affidavits. And I think that holding by the judge is an abuse of discretion because he's saying nothing has changed when in fact he based his previous ruling denying us attorney's fees with a motion to compel based on his assumption that there was no fee agreement. Now we had provided a fee agreement by this point, so that's how I would answer that question.
But you always had, in both affidavits, Mr. O'Leary said the clients, well, what I read before, have agreed to pay or
Correct.
have paid.
And I think that's all that's required. I think the judge's ruling, and again, we're arguing that order, the Index of Record Order 168, where he denied us attorney's fees on the motion to compel, is error as well.
When Judge Mackey addressed the fees to be awarded under the shared well agreement, he went on to say, as I read the same page of the minute entry, that if there were an obligation to pay, then he went on to say, but I'm going to look at the reasonableness of the fees, and I'm going to find that X amount of Mr. O'Leary's fees were reasonable and X amount of Mr. THIEME's fees were reasonable. And he does that. So that tells us, doesn't it, what
Well,
the judge...
I don't fully agree with what you just said, Judge. He sort of does that. He doesn't fully do it. He says, approximately $10,000 of Mr. THIEME's fees were reasonable. But he doesn't go through any sort of analysis. I mean, the starting point here was the fee application. The fees that they objected to, which were somewhere around 30 hours of our fees, my fees, I think, mostly, and that was the starting point that the judge should have started at in looking at the fees. Instead, he kind of just eyeballed it and said, oh, well, Mr. THIEME, about $10,000 of what he did was reasonable. Everything else wasn't. So, but I'm not going to give him any fees anyway because
Well,
there's
so
no...
what should Judge Mackey have done?
What Judge Mackey should have done is what Judge Mackey usually does in every other case I've seen him do, which is to look at the fees, the total fees incurred, look at the objection that was filed by the defendants in terms of the 30 hours or so, determine which of those 30 hours were reasonable or not reasonable. Some of them we conceded, other ones we didn't. And then based on that, he should have determined a reasonable award of attorney's fees. He shouldn't have deducted, I think certainly to reduce it by 75%, even for Mr. O'Leary, was far too much. And I think to award the plaintiffs nothing for the time that I spent was also an abuse of discretion, because how was the case supposed to get to trial? I mean, there was a lot of depositions, discovery, all the pretrial work that someone had to do, and I don't see why the plaintiff should be punished for the fact that I did it at a lower rate than Mr. O'Leary would have done it for. So
Is there a... Oh, okay. Moving on to the fees your appeal from the denial of the fees on the motion to compel. You and I have just engaged on an analysis that Judge Mackey did, saying, A, there's no obligation to pay, but even if there were, my assessment of reasonableness is ABC. Did he do that kind of secondary analysis on denying fees on the motion to compel?
I don't believe so. I think let me, if I may have just a second, I'll try to find the order. The 168, the order from January 26, 2016. No, he just said that as of this date, the plaintiffs have not established that they have incurred any costs, including attorney's fees, in pursuing the motion to compel. So that was, and that's on page 2 of the order dated January 26, 2016. That's the index of record 168 order that I'm talking about. And then again, if I can just jump ahead to the end, which was a supplemental fee application, where you can really see, his whole logic going off the rails, where when he awarded us less than 1% at this point of the attorney's fees incurred, he gave us $12.50, which was 25% of the attorney's fees incurred by Mr. O'Leary in reviewing the work that I had done in responding to the motion for a new trial. So in other words, none of the work that I did. Apparently he felt there was no obligation to pay that, but somehow the clients were obligated to pay Mr. O'Leary's fees, and only $12.50 was what he awarded, which was 25%, even though we had won the entire motion. I think he just kind of mechanically carried over the logic from his earlier ruling onto the supplemental fee application ruling, and it just doesn't make any sense. It doesn't hold any water. I mean,
When did the court make that ruling on the supplemental fee application?
well, that was after we had filed notices of appeal. Then this court had told us to file, I think, an amended notice of appeal. So that was somewhere around index of record 333.
Okay, we can look it up. We're fine.
Toward the end, I'm kind of running out of time. I have a minute left. I'd like to reserve that, if I could, for anything else.
Okay.
Thank you.
I would like to address the argument raised by Mr. THIEME about fees awarded under 1103B. And those fees that they're now stating on appeal should be awarded in their entirety for the quiet title action. You have to look at what 1103B was designed to do. And it was designed to mitigate the expense and the burden of litigation. Now, the THIEMEs had no expense nor burden, neither did the Webbers, because they didn't pay anything. So, or there was inadequate evidence that there was payment.
But that statement still assumes that they're not obligated to pay anything.
There hasn't been any payment, so there hasn't been any burden. The very threshold of 1103 is we're not going to award fee. The design of the statute is to...
Cite a case that says that says that that a client has to pay attorney's fees before the attorney can submit a fee affidavit.
Well, there has to, if you look at the Lisa case,
I understand, yeah.
and it states there has to be a genuine obligation, and they talk about the payments that were owed by the community to the marital community. There weren't any because it was not reasonable to think that there could be. And so they stated in the Lisa case, we're not going to allow attorney litigants to get their fees back because it's not, per se, it's not a genuine obligation.
And the per se rule might apply if there wasn't evidence to the contrary. And here we have a licensed attorney, a partner in Mr. THIEME's law firm, saying, averring under oath, penalty of perjury, the clients are obligated to pay these fees, have agreed to pay or have paid these fees. What authority do we have to brush that aside?
Well, I think the least the court would have said this is illusory. Okay, but this obligation is illusory if there has not been payment. And there has not been, I mean, there certainly has not been payment in this case to date. My clients, on the other hand, paid over $140,000. That's a burden. That's a burden. Now, my clients can't get fees under 1103B because they did not they didn't dot those I's across those T's. They didn't have to. And so they're not claiming fees under 1103. They're claiming fees under 341.12, 341.01. But the obligation, the genuine obligation, is what the court was looking at in this case, and I don't think that's an abuse of discretion to say you haven't shown me. I mean, when we submitted our application for fees, I submitted monthly statements detailing all the work that I did and an indication at the end of the statement that it had been paid, or there was a balance due that was paid the following month. In the end, that was a genuine financial obligation that was recognized by the court. But because the court declined to award fees to the SZEWCZYK, saying they were not the prevailing party, then we didn't get fees. I think I'm out of time.
Thank you.
Judges, very quickly, just wanted to tie up a few loose ends. Lisa versus Strom, the case does not require actual payment. The case requires a potential out-of-pocket, is what the court said in Lisa versus Strom. It was a completely different situation. The attorney there was he was his own firm, and he was representing the marital community, and had no real obligation between him and his wife and the firm, because they were all one and the same entity. I'm not a partner at O'Leary Eaton. I'm an associate. I'm an employee. I don't have any fee agreements with plaintiffs because I can't. I don't individually represent them. Under the Hunt case, I could individually represent them and still recover my attorney's fees. And finally, the evidence at trial, which Mr. Coughlin did not provide transcripts of what happened in trial.
You made that statement. You could not individually represent. Say that again.
What I was saying is, under the holding of the Hunt case, even if I were not working for O'Leary Eaton, I was just Mike THIEME, Esquire.
Okay, so it doesn't apply. So
Right.
you are okay.
All right, I'm out of time, but I was just going to add that the evidence at trial did show that the plaintiffs did pay for some of the years, so there was not a material breach in our view.
Where's that evidence in the record?
Well, it's not, because they didn't give the transcripts.
Well, neither did you on this point.
Well, it's not my burden to show something that.
All right, thank you. Thank you to both sides for your argument and your briefing. We'll take the matter under advisement and issue a decision in due course. Now we'll recess for a bit to allow the next folks to come forward.